Thank you, Your Honor, for allowing me to speak today. I'm very disappointed that the prosecutor has decided not to retry Mr. Weinstein on the sexual battery charge on which the defendant was indicted and about which I testified during the trial. As you know, 10 members of the jury voted to convict the defendant on that charge and 2 did not. I really wanted the prosecutor to retry the case, and I asked him to do that because for 10 years I've done everything possible to seek justice for what the defendant did to me. I testified in the New York case as a Molyneux witness, which is like an 1108 witness in California, and then I was willing to testify in Los Angeles as well. I believed in our system of justice, and I hoped that I would obtain justice if I testified truthfully, which I did. Unfortunately, I have not achieved the justice that I had hoped to obtain. That is why it was so important to me to be able to have a retrial, but now I have been denied that as well. I wanted the retrial because even though the defendant has been convicted in New York and California of crimes against other women, I wanted him to be held accountable for what he did to me. Yes, the defendant is sentenced by Your Honor to 16 years in prison, but I believe that if there were a retrial in reference to the sexual battery of me, it is likely that he would be convicted and sentenced to even more time than Your Honor sentenced him to previously. I think that Harvey Weinstein should be punished for any and every crime he has committed against women, and that includes the crime he committed against me. I believe that if sexual predators learn that they will be prosecuted and punished for every crime they commit, it may deter others from committing crimes of sexual violence. That could help protect women in the future. Harvey Weinstein has escaped the retrial as to me, but he will always be remembered not as the great producer, but as the convicted felon and sexual predator that he is. I hope that Mr. Weinstein's daughter is never the victim of a crime against her. But if she is victimized as I was, I pray that she will never be denied the justice that I was denied today.
I'm going to read the statement of Jane Doe number 5 and identify her. She's given permission to use her name and her photo, which I will distribute. Here's the statement. Her name is Kate Jaggard. I would like to thank with immense gratitude the 4 other Jane Does who testified in the recent trial of convicted rapist Harvey Weinstein in Los Angeles. In my opinion, the conviction was a win for all sexual assault victims. I empathize with the grueling and deeply personal journey of those who fight for justice in sexual assault and rape cases. I spent many years, 5 years to be exact, seeking justice against Harvey Weinstein. I cooperated with the district attorney and spent many hours speaking with law enforcement over a number of years. I testified before the grand jury, and as a result, many charges were filed against Harvey Weinstein in reference to me. Those charges that were filed were 2 counts of forcible oral copulation and 2 counts of forcible rape. Unfortunately, and with deep disappointment, however, although I was willing to undergo cross-examination at trial, due to circumstances that were beyond my control, I was not able to appear for trial. As a result, those charges were dismissed. I took some comfort from the fact that I believed that I would be able to give a victim impact statement at the sentencing of Harvey Weinstein. I was deeply disappointed when the judge decided that only Jane Doe 1 would be permitted to give a victim impact statement, and neither I nor any other victim for whom charges were filed were permitted by the judge to make a victim impact statement at sentencing. This decision was fiercely appealed by my honorable counsel, Gloria Allred, and I am very appreciative that she and her partner, John West, have fought all the way to the California Supreme Court for the right of a victim for whom charges were filed, and also for Me Too witnesses to be heard at sentencing, even if there was no conviction. in their case. It is our birthright to be safe, respected, and heard, and not violated. It's our constitutional right to be heard. Time is up. Victims will not be silenced anymore. And this is a photo of Kate Jaggard, and she is Jane Doe, number 5, and she resides in Australia.
I would like to say I'm sad that I didn't get the chance to have my case retried, and now I know I tried my best, and I'm very glad. But when there are charges filed against the victim should be allowed to have a victim impact statement at the sentencing. I wasn't allowed to come for sentencing because I wouldn't be allowed to speak. And it's very disappointing because it would have felt amazing to be there with the other women that I haven't met and that I've been going through the exact same thing. And to not have the chance to be able to meet and be in each other's atmosphere is really a shame, because those are the people that also went through a similar situation as me.
Thank you. Just a little small correction here. She would have been allowed to come as a member of the public, but the prosecution could not pay to bring her in because she was not permitted to give a victim impact statement. Just to bring everyone up to date, the petition for mandamus, which I did file with the Court of Appeals, was denied. Yesterday, we filed a lengthy brief with the California Supreme Court, and we can provide the case number for that, which was provided to us yesterday when we filed that.
Could you send the brief?
Pardon me?
Could you send us the brief? Email the brief?
Yeah, if you request afterwards, just send me an email saying, please send me the brief.
So is
to
this
the California
more-
Supreme
Thank you so
Court,
much.
we will send that to you.
this
If you
more-
want the statement of Kate, well, you have it, right?
Is this more for the future? Because obviously there's nothing that can be done about that now.
So the question is it moot?
Yeah. Well, or is it
Are you seeking a precedent?
for use in
Yeah, well, here's,
further
here,
cases?
yeah, it's a good question. This is a case that involves whether a victim has a right to give a victim impact statement even if there has been no conviction for that victim who testified at the trial, where charges were filed, but there was no conviction. We have found no case, no precedent at all on this issue, no published case. This will be, we have argued in our brief, essentially an opportunity for the court to give guidance, the Supreme Court to give guidance to lower courts on, first of all, what is a victim? And this, of course, is what the California Constitution cites as a definition of a victim. It says, a victim, the retained attorney of a victim may enforce the rights enumerated in any trial as a matter of right. And of course, I made the request on behalf of all 3 of my clients who were victims. This is California Constitution, Article 1, Section 28B, quote, a victim shall be entitled to the following rights. 8, to be heard upon request at any proceeding, including sentencing, or any proceeding in which a right of the victim is at issue. We're talking about the denial of a constitutional right. We're not just talking about a statute, which is a law. We're talking about a constitutional right. It's called Marcy's Law. So we filed that brief. We hope, so the question is, well, the sentencing is done. Would it be too late for them to do anything? This is like the abortion cases, where a decision can be made even after the person has given birth, or not had an abortion, because it is a fundamental right that is capable of repetition. In other words, others will get pregnant, others will have to decide if they have an abortion. So the fact that it's too late for the person who filed because of the glacial pace of the judicial system does not mean that somebody doesn't have a right. It's still within their power to decide this case for future victims. So yes, I'll be happy to send the brief. It's extremely important. And if the Supreme Court denies us, there is no right of appeal for victims. There is right of appeal for defendants, not for victims. So we're going to find out whether the Constitution says what it means and means what it says. It's as simple as that. We think it's clear, and but we'll see. The petition for mandamus is the only route for a decision. If they would deny it, then the only option is to go to the legislature and try to pass a law which will make it clear. But we think it's an important fundamental right. So that's filed on behalf of all three of my clients